everyone to our town hall with General Sessions Court officials and personnel. I'm Hanson Tipton. I'm the president of the Knoxville Bar Association. I appreciate all of our attendees being here, but I really appreciate all of our speakers being here today. And I will go down our list real quick and point out who's here today. We've got Karen Frost, who's a supervisor with General Sessions Court Clerk Criminal Division. We've got Randy Kenner, Chief Deputy of Knox County Circuit Court. Mary Lindsey, Court Director, Knox County Juvenile Court. Richard Major, Magistrate and Knox County Criminal Court Administrator. Esther Roberts, Knox County General Sessions Judicial Law Clerk. Kelli Sharp, Civil Sessions Court Clerk Supervisor. Mandy Scarbrough, Assistant Supervisor, General Sessions Court Clerk Criminal Division. And then hopefully we're going to have Charlie Susano joining Randy in his office or in one of these windows. He's the Knox County Circuit and Civil Sessions and Juvenile Court Clerk. So thank you all for being here today. I'll mention just a few housekeeping matters off the top. We are recording this session, so if any audience members need to leave or get disconnected, it will be recorded and it'll be posted on the knoxbar.org website for viewing later on. I'll also point out that we have a Q&A box down at the bottom of your Zoom window. If you've done one of these Zoom webinars with us before, you'll remember that. If you will type any questions that you have, it might be helpful to me if you can tell me in your question which of our speakers you would like me to ask, or it could be an open question to all. But if you'll put your question in the box, Marcia and Tammy are watching and they're going to try to make sure that I see all the questions that get asked. So with all of that being said, thanks again to everyone for being here. How's everyone doing during the COVID-19 pandemic?
Best we can.
Yes, you can. I know we've spoken before we started here today, and each of you was proud of the fact and pointed out that the courts have stayed open this entire time. Esther, can you tell us a little more about what the last, I guess, 8 weeks have been like for the courts over there and in the building over there? A lot of attorneys have been staying away, but I know that all of you people have been dutifully going to work these past 8 weeks. Tell us a little bit about that.
Well, first I want to compliment the court clerks, both for the civil and the criminal division, because they're the ones who have kept us going the last 8 weeks. They've reset thousands of cases and done a Herculean job of keeping us on track as much as possible. When all this happened, of course, the Supreme said we are still open and we want to be open for cases, particularly with inmates, to try and one of our directives early on was to minimize the jail population. And so our 5 judges, the General Sessions judges, went into a weekly rotation where we had 2 judges on the bench instead of 5, simply because civil was stayed. So we have timely heard all of the inmate issues that have come up, to get people processed as quickly as we can, and all with social distancing and those kinds of things. So it's been at the beginning, I think it was very stressful for all of us here. But after the first week or so, we realized this is a whole new normal and we just have to roll with it and continue doing what we can to provide timely access for justice to all of our litigants. So that's what we did. PBA has done a magnificent job, I think, of trying to keep the building open for all the necessary things. And they've certainly been very gracious to us to move civil into the main assembly room so that we can accommodate as many litigants as possible under the Supreme Court directives. So it's been a challenging, interesting time these last 8 weeks, and I think we're all glad to start moving forward, and good to see lawyers back in the courtrooms now and start moving these dockets forward.
Thank you. And now I think I see Charlie Susano Zoom bombing Kelli back there.
Charlie Susano is having network connectivity problems, so he just came over to the old courthouse.
All right. Well, welcome and thank you for being here, Charlie.
Good to see everybody.
For all of us, and I know we've all read the plan that was submitted to the Supreme Court by Judge McMillan, and the plan that was approved as amended by the Supreme Court, and it points out specific factors for each court in reopening or in staying open. And Richard, I noticed that there's a preamble to this document, and can you explain how the preamble interacts with the rest of the submitted plan for the 6th Judicial District?
Sure, and Hanson, like you were saying, this document that's approved by the Supreme Court was developed by each of the judges in their specific courts, and then coordinated and put together by Judge McMillan, who's currently presiding judge for the district. But the preamble that Judge McMillan drafted is unique in that it really applies to all of the courts. So we have a lot of court-specific information, but we do have some rules of the road that are going to guide all of our courts. And they're mostly common sense things that we understand are the norm now, but it's good to have them spelled out and to go over those. One is simply that social distancing is expected, both inside and outside of the courtrooms, and it is the responsibility under the order of the courts to ensure that social distancing occurs. So, just anticipate that as you have your client interactions. Another point that I think is important for lawyers is in the preamble is the portion governing witnesses. Most of the individual courts have some highly specific rules about if and how many witnesses will be allowed in the courtroom. But beyond that, the preamble, as a general matter for all courts, indicates there'll be no more than 2 witnesses permitted in the courtroom at any time. And it actually goes beyond that to even cover the area outside of the courtroom. Obviously, the goal here is so that we do not have lobbies, full of people while we have a courtroom with 10 people. That way doesn't make any sense and doesn't accomplish what the courts want to see happen. So, think outside of the box if you have cases with multiple witnesses and how you might coordinate that. But keep in mind the expectation is going to be about a couple of witnesses, brought into the immediate area around the court when you're here on any given day. And also the courts are making efforts across the board to try to limit the number of cases on any one day, which is hard because, like Esther said, we're behind and everything. We've been doing our best to keep essential services running for the last 8 weeks, but obviously things are being rolled and those dockets keep growing. But we're going to try to ensure that a limited number of cases are heard on one day, and that's going to involve things like staggered docket times and putting caps on individual cases for any given day. So just be on the lookout for those things as you come into the courts in general right now.
Thank you, Richard. Kelli, I hate to put you on the spot, but Randy told us that this morning you had your first big civil docket, and I was wondering if you and Randy both maybe could tell us how that went and how it has gone in putting these measures into place for getting large numbers of cases heard again.
It went well. We were able to sit people upstairs and downstairs both, and the attorneys had their agreements and resets ready, so we were able to get a lot of those out of the way. And there was a couple that needed to have some trials, so those were put to the end of the docket. I think Judge Cerny was doing one at 10:30 and 11:30, so he's about to wrap it up. But as far as everyone, social distancing worked. Everybody had their masks, so it was pretty good. I was really proud.
Yeah, we have, I think we have 89 seats in this small, large assembly room, which, that seats, well, a lot more than 800, or a lot more than 89. So we have everybody pretty well spread out. And once we filled the lower part up, we started moving people upstairs, and everything went fairly smoothly today. And so it's a good sign for what comes in the future. We have some bigger dockets coming in June. So today was a really good test, and it worked very well.
That's good to hear. Going through the plan submitted by Judge McMillan that was approved by the Supreme Court, looking at the section on Knox County General Sessions Court, I noted that PBA or PBA's designee shall pre-screen all persons coming before the court. This pre-screening process shall include a brief interview regarding any recent illness or exposure, as well as non-invasive temperature check. And of course, we all know why that's being done. How has that gone so far? Or has that started?
It has started. They're doing it not just for us, but for the whole building when people come in. So it's worked pretty smoothly. I'm not sure where the folks are. They're from. Kelli may know, but they are screening when they come in. and they have masks there. So if somebody doesn't have masks, they've been given a mask. I don't know how long we'll have masks before we start to run out, but that's what's been going on so far, and it worked very well. At least it worked well on Monday and today. I wasn't there yesterday. Kelli may know more about.
If I can add this real quick, there was some discussion as to, whether or not clerk employees or PBA employees should be providing these questionnaires and temperature checks and so forth. And we were concerned about possible liability issues on down the line. So what PBA was able to do was contract with a group that provides these medical professionals, if you will, and they have been giving those questionnaires, masks, temperature checks, and so forth. And I think that was the best solution for all parties involved, and it's gone very well.
And is that, I would assume that's obviously the case for not only litigants, but also attorneys as well?
That's correct. Everybody that comes in.
And the plan that was submitted in that same section mentions that those persons who shall come before General Sessions Court in person shall wear a mask or similar personal protection equipment.
Yes.
And we all, as attorneys, we all know what shall means. But can you explain to our audience what are the expectations there and what is being done in practice?
I'll let Esther, you want to answer that?
Sure, I'll be happy to. The General Sessions judges insisted on this to try and protect all the litigants as well as the court staff from any sort of infection. So, but they're being very liberal as far as how they interpret the idea of masks. So a person can tie a bandana around as long as their nose and mouth are covered in some way. They can even use a t-shirt if it's someone who doesn't have a mask. Right now, as Charlie said, PBA is providing a free mask to anyone who comes in for court business. But again, we don't know about the supply. That's always the question. So certainly if someone has their own mask, please bring it, and please be prepared to use it anytime you're in the courtroom of a General Sessions Court. And I would assume all the other courts, but I'll footnote that question or that piece of the question to Richard. But yeah, you've got to have your nose and mouth covered anytime you're in a General Sessions courtroom, civil or criminal, for the foreseeable future until, the order, which is EM 2020-00428, I think is the Supreme Court number. As long as that order is in effect and our operating guidelines are in this plan, then that shall is mandatory. But if somebody comes and they don't have a mask for some reason and they don't get a free one, they'll get one free reset, so to speak, because the judges do understand this is a whole new protocol. So if somebody comes and they don't have a mask, they're not going to get penalized, even though they may not get admitted to the court that day.
I'm curious if there has been any pushback on the mask requirement so far. I've seen stories on social media and in the news of and not necessarily in Knoxville, but just nationwide, people being angry about the requirement to wear masks. Have y'all seen any pushback on that?
I haven't seen it in the 2 days I've been there. In the times I've been there, nobody said anything, or nobody's even really objected to it so far.
People have been remarkably cooperative.
Mm-hmm. Very cooperative so far, very understanding. And again, we're just grateful to PBA for providing that pre-screening service and providing the masks at this point. And I think Clerk Hammond may have been doing some masks as well and some outside some of the criminal court. So
I think that's right. Having talked with Mike Hammond, the masks that he's been providing these first couple of days are a limited supply, and I think they're happy to do that. And PBA at this point does not intend to provide masks going forward. So that's sort of been a bridge as the process has started. So obviously for members of the bar, be aware the requirement is not going away, but you're going to want to ensure that both you and your clients are carrying with a mask. Like Esther said, though, that's going to be, liberally interpreted, but you don't want to come empty-handed. And I think to the point Esther made earlier too, the order itself that requires masks is limited to General Sessions Court. It's not a court or building-wide order. However, if you go through the individual court's instruction, they certainly are pro-mask, and several of them spell out specifically that attorneys and litigants should feel comfortable bringing whatever PPE they feel is appropriate into the courtroom at any given time. But also, since, like Randy said, since they're instituting the temperature checks at the front door for Sessions Court, it is likely that anyone coming in, is, at least during early court hours, is going to be dealing with being stopped for the temperature check. So again, even if you're not going to a Sessions Court, plan ahead, be aware of that for both you and your client.
Esther, you mentioned that at the point where the free masks run out, if someone comes without a means of covering their face, they'll be given one free reset without a penalty. Would that also be the case for someone who fails the screening process, who shows up and might have a slight fever or something like that?
Yes, if they're denied entry for those, if they don't pass that pre-screening, then they'll get reset automatically.
All right.
We have cards down there that we have made up. If they fail, and we've yet to have one, I've been there every morning this week. If they do have a temperature, we have a card that we give them to call us back for a reset date, and we can tell them, when their case will be heard. So they have the information given to them if they test it or if they have a fever. So far, no one has entered the building with a temperature.
Okay, thank you, Karen. And that's speaking on behalf of the Criminal Division of General Sessions Court. You've mentioned social distancing and the efforts being made, and reading through Judge McMillan's plan, he goes into great detail, especially in terms of what's happening in the main assembly room to enforce social distancing. Can some of you maybe address that and maybe explain how that is happening in practice? Maybe Kelli, from what happened this morning.
Everyone was pretty sociable as far as dealing with it. There was no angry people. They had some of them were a little confused, which it's all new for everyone coming in now with being screened at the front door. But as far as we have all the seats roped off in the assembly room every 6 feet, so that way they have enough room between them. We even have extra chairs along the back wall for extra seating as well, 6 feet apart. Me and Esther have been the runner in between the judge and the attorneys to keep them from being approaching the bench and everything with the clerks and the judge sitting at the bench. So it's been pretty good. Very pleased.
Good.
And we have 2 additional PBA staff. We have a bailiff there who stays at the bench with the judge, but we also have 2 PBA staff, one downstairs in the main assembly room and one upstairs in the balcony area, that can just help kind of answer questions, move traffic as we, people as we need it, enforce the mask rule. When people come in, sometimes they forget and take their mask off, and they remind them to put the mask back on. So we have additional staff to just help manage that larger space. I think it normally, as Randy alluded to, I think normally the main assembly room can hold 612 people, but we did a 6-foot radial distancing, so it's not just side to side. Obviously, it's front to back. So as Kelli said, some of the rows are completely cordoned off, so it's an every other row skip. So we maintain a 6-foot radial distance for each litigant or attorney that comes in. I will say the one comment I heard from some lawyers today is we kind of thought the lawyers would sit in the back seats. And I would encourage the attorneys to do that, just because they don't have to worry about getting around yellow security tape anywhere in the row that they might be sitting in with the other chairs in that row that might be taped off. So the back chairs are spaced 6 feet apart. And if attorneys have other courts to go to, or a busy day, it may be easier for them to sit in the back and then approach the podium, and then they can just go when they're done and not have to worry about that.
We might have to reserve some seats for the attorneys. We haven't done that so far, but we might do that going forward, so that they'll have a place that's always there if they're moving between the courts.
Especially when you get to the larger June dockets you were talking about.
Yes, sir.
All right. And I see we do have some questions in the Q&A box. I'm reading those, and I'll try to sprinkle them in where they make sense in terms of how the conversation is going. We do have a question about, are pre-screenings occurring at both the main entrance and the Hill Avenue entrance to the City County building, or have entrances been limited to the main entrance?
Been limited to the main entrance. They said they were closing the lower level off to just handicap and employees, in which they have done. So everything is directed to the main entrance.
Okay, thank you. And then, let's see. Let's talk a little bit about, the plan defines non-essential persons as far as who can be in the courtroom. Can you explain a little more, whether it's Esther or whomever, who is essential?
Well, defined in the general sessions part, and I'm happy to answer that, and I've got it here with me. Essential is defined to be parties, witnesses, let me get to the right place, attorneys. One question that we've had is, and I may be anticipating one of your questions, Hanson, but one question that we've had is support personnel, and they are not included as essential people right now, and the press. And of course, the press is always welcome, but there's a caveat there that we have to deal with the social distancing guidelines and the parameters of the Supremes. So in a criminal general sessions courtroom, right now we're limited to 10 persons that are identified as essential. And I did speak with the judges about this before this call to make sure that I was clear about this. So we have 9 people in the courtroom, and there's a reporter that wants to come in. That reporter is welcome, assuming they've got all the right personal protective equipment, et cetera, and they've passed through the screening. If we have 10 people in the courtroom, we may ask the press to wait because we're trying to serve the litigants first. And the press has been very understanding so far, and we're grateful for that. In the main assembly room now, you know, it's 80 plus folks. So we have a docket of 400 cases. There may be times then that we need to ask the press, please, can you wait? Again, to try to move the docket forward because all these litigants have been waiting so long. But the message that we want to convey on behalf of the judges to the press is always welcome. We're just having to deal with a very limited number of folks, of human people in each courtroom. And like I say, so far the press has been very understanding and patient, and we're very grateful for that. The judges are. We will ask if they're going to do a criminal thing, you know, if they want to be in a criminal court, they need to fill out their regular request, press request. And if they're going to bring a camera in, we're asking all the media outlets to share the video and just have one camera. Because again, for every camera operator, that's another human that's in the courtroom. So
Right.
we're trying to be as certainly as transparent and open as we can, while still never violating that Supreme Court order, because the Supreme Court's the one who approved this reopening, and if we ever violate it, we don't want to get shut down, because that would only harm the very litigants that we're trying to help.
We have a question from the audience. Are employees being screened from the parking garage entrances to the city county building?
I don't think
Court,
so.
court employees?
No.
Not in the building generally. Speaking for the clerk's office, they are being screened. Those individuals are, but not everyone coming into the building as a general matter.
All right. We have another question about essential versus non-essential. Would student attorneys from, say, the legal clinic and their supervisors all be considered essential, or would only the supervisor be allowed in the courtroom?
That is a really good question, one I've not considered. I would assume if the student attorney is going to be litigating and their attorney advisor is the supervisor, then they would both be allowed to come in. That's my assumption. But they're still going for 2 people. So there again, we're just going to have to work around those numbers. I would recommend, speaking sua sponte, that be minimized, just because our primary concern is to serve our litigants, and I understand student attorneys certainly need the exposure and the opportunity, but right now for these next few weeks, I would say it would be kind to our litigants if you'd minimize that, just because the barred attorney can do the work that the student attorney can. So therefore, if we eliminate the student attorney for just the next few weeks, that's one more person we can get in the courtroom.
All right. Thank you. Switching gears for a little bit, we'll come back to regular general sessions operations, but Mary Lindsey is with us from the Juvenile Court. And Mary, could you tell us a little bit about how, obviously your court is different in a lot of ways from the courts we've been discussing. Can you tell us a little bit about juvenile court operations since the pandemic began, and also what's happening under the plan that was submitted by Judge McMillan?
Sure. So the original order that came down from the Supreme Court has operating under limited emergency or hearing limited emergency cases only. However, our intake office did remain open, so we did assist folks in filing petitions and so on and so forth. But now, starting this past Monday, everything's been open for regular business, 8 to 4:30. Now our lobby does remain closed. The restrooms in the lobby, however, remain open to those attending hearings or conducting other court business. I've been hearing about masks being required. That is not a requirement here. We strongly encourage folks to wear masks, employees as well as those attending court. However, those are not being provided here at this court. We also have posted signs on our doors directing parties to inform our court personnel who are out there checking them in to immediately notify folks if they are ill or running a fever or anything like that, because as well we don't have anyone out there taking temperatures, etc., or doing any kind of pre-screening that's being done other than just the face-to-face check-in kind of thing. We as well, our preferred method right now of conducting hearings is going to be through the use of technology. So to reduce any in-person contact, we're asking, attorneys or parties to notify their case managers that are here as soon as practical of how they would like to proceed with their cases. And then, we're asking that they provide their emails so that we can, if they do elect to go with Zoom or Skype or some other kind of platform, that we can get that information to them as to when their case will be heard and so forth. Now, also, we're not, because our lobby is closed, now we're not allowing parties to come in until they have been called by the clerk of that particular courtroom. So when people check in, we are getting their contact information, phone numbers, and asking that they go sit in their vehicles. If they are people that are actually going to be having an in-person hearing, then we will call the clerk will call them and say, you are to report to the courtroom now. Witnesses, same thing. When the testimony is needed of that witness, they're going to be called at that time and asked to come to the front entrance, and then there will be somebody out there, to bring in to see that they get to the courtroom. So we're trying our best to limit in-person contact as much as possible, and so far, although this has been a good week to test all of this because we don't have as many cases on the docket, that's going to change come next week and the weeks forward. So, so far it seems to be working well, that check-in process and so forth. But we do have folks that we understand are going to be riding the bus, or they're going to be dropped off by other individuals. And so we've thought about that, and the way we're handling that at this time is that we're going to, those people can wait on the covered porch, and we're working with PBA to possibly get some benches out there so folks have a place to sit. We do recognize as the number of cases increase, the number of folks waiting is going to increase. So we are thinking about some alternatives and how to address those increased numbers should we need to do that. For the most part right now, when people are asked for their information and are told that we will call them, they're just going back to their cars and sitting. So we're hoping if it's a situation where, especially if the weather's not the best, it's raining or something, most people are going to go to their cars and wait, and so that's going to free up that space for those people that do not have cars here and have ridden the bus or whatever to sit out on the covered porch. However, again, If we need to make adjustments, we are certainly going to make the necessary adjustments to make sure that we're meeting the needs of all the public that are having business or needing to do business in our court.
Thank you, Mary. We also had a question from the audience while you were speaking. For you specifically, what is the preferred process for an attorney to get an add-on to the docket for a bond hearing request, for example?
Okay, that person should just contact that worker, that court worker. There is an assigned court worker on all the cases. They just need to contact that worker, and they should be able to assist them in getting that set up.
All right, thank you, Mary.
And if not, if they have difficulty getting that established through that worker, please call a supervisor, court director here. Ask for, there's 3 court directors. I mean, we're available, and we'll see that all gets taken care of quickly.
Great, thank you. Going back to the city county folks, I have a question. Is the attorney's entrance at the side still open with a separate screening, or does everyone have to go through the main front door?
The side doors are open.
The side doors are open?
Side doors are open.
Okay.
And just noticed the last few days, they have, the attorneys are being screened as well with the temperature check and answering the questions that are asked.
Okay.
And I can tell you that Karen Frost personally checked my temperature yesterday, didn't you, Karen? So we are all being checked.
That's good to hear, Charlie. Thank you.
The health checkpoint table is directly across from, as you come in the lawyer's entrance, you'll walk right into that table. So
okay.
Litigants or witnesses, the public come through the main security gate in the front of the city county building. Once they pass the security checkpoint, the PDA security direct them to the health table. And it's just past it on the right. If you're familiar with the building, it's basically blocking the entrance to the small assembly room.
All right. We've had 2 questions, and I know the plan discusses detainer warrants, and we've had a couple of audience members wonder if there's a ballpark estimate on when detainers will begin again, or at least detainer actions that are only for damages and not possession.
That's a good question. There's some limited conduct cases that are being heard, but the judges have to approve those as a special exception. So until the Supremes allow us to move forward on those items, they are not going to be heard unless a judge has approved them on a case-by-case basis. And certainly folks are, they can contact the clerk's office, they can contact me, and, to try to ask the judge if they think there's a specific warrant that needs to be addressed. But that's from the Supreme saying we can't do that. Even, I have a note here, even writs for businesses are being stayed at this time. So it's a pretty broad prohibitive order, but I do know that there have been some conduct-related cases that have moved forward.
All right, so on a case-by-case basis, basically.
Yes, sir.
All right, thank you. We have a question for criminal court matters. So Karen or Mandy or Richard, the question is, what is the court doing for the booking process, and will the arraignment immediately follow?
Booking process has been taking place since day 1. Booking has been open every day.
Right.
We just started last week taking the bookings that come in and having them arraigned. To try to expedite those arraignments and get those people an attorney. As normal, not all are aware of their court date, or it's been reset. But we had more today of bookings and bonded arraignments than we've ever had since March 13th. So the word's getting out there that we're doing the arraignments. Bookings are going on every day. If they're scheduled for booking, they're to be here at 7:30. They're booked and told to wait out into the mezzanine. We will call them in one at a time when the judge judge gets on the bench and arraign each one individually. So we're up and working, trying to expedite those cases.
And I know Esther had told me that arraignments are being conducted shortly after booking at this time to facilitate as much as possible the defendant only needing to enter the city-county building one time for booking an arraignment the same morning if possible. Is that right?
That's correct.
All right, let's look at some more audience questions. We have a question about the circuit court clerk, and so Charlie disappeared, but Kelli, maybe you can help out. Will subpoenas for in-person depositions and documents be issued by the clerk's office, and will deponents be ordered per subpoenas to appear and give testimony at this time?
And that's for circuit court's
Yes.
office. I'm not going to be able to answer that because I'm not 100% sure on how Judge Ayler and Stevens and Davis are doing that, because their court's a little bit different than ours.
Right.
So I don't feel comfortable answering that question.
I'm sorry to put you on the spot. I thought maybe
Okay, it's totally
Charlie
fine.
might be within earshot there.
Yeah, no, he's took off. I think he got a call.
Well, we will table that one and try to get an answer for that, because I'm interested in the answer to that question as well.
Yes.
We had a general question that about the plan says, quote, shall reopen for business on a limited basis on May 11th. And this audience member is wondering what kind of cases are being heard now, civil and criminal emergency matters. How do we know what the, quote, limited basis is?
I have tried to contact most of the attorneys that deal with our court to let them know our judges have put a cap. They want no more than 400 cases on a docket, and that's 50 per attorney. Because we do deal with a lot of attorneys that have these big bulk of
Collections work.
So with that being said, they have been told 50 cap per attorney. I've really tried to make a lot of phone calls to some of these attorneys, especially out west, to let them know 50 cap. Try to have as much as you have, done. Your agreed judgments, your non-suits, your resets. If you know all that information before you come to court, tell the clerks, and we'll try to get all that pulled so that way we're only sending so many warrants into the assembly room for the judges to hear. It can get done a lot quicker.
Hanson, for the criminal trial courts, I think the message is that I think the judges want to send there is they are open for business. Per the order, they can't do jury trials. However, everything else really is on the table. If it's an inmate case, those are being heard daily through video conference. If it's a bonded matter, even pleas and sentencing and probation violations, those are being handled as well, generally by video conference as well. If it's a contested matter, those can be heard now. We just want to know about it ahead of time so a time can be scheduled to either facilitate limited people in the room or a video conference, depending on the individual judge involved. But please contact the clerk because it probably can be dealt with.
Thank you, Richard. And you mentioned that there are no jury trials, and that, of course, has been handed down from the Supreme Court and applies to all of us in civil and criminal. Could you maybe explain why it's so difficult to impanel a jury and hold a jury trial logistically, given what's going on right now?
Obviously we can't speak, for the Supreme Court, but just, observationally, I can tell you locally, just trying to talk about what normal will look like when we move past that limitation and how we would deal with that. I think everyone's operating under the assumption that social distancing protocols are going to be with us for some time, probably longer than the prohibition on jury trials. And what's that going to look like? And obviously it's a challenge. Courtrooms were not designed for social distancing. I mean, I think Esther was telling you maybe 80 something people in the large assembly room. That room was designed for hundreds of people. And that gives you an idea just how much capacity you lose. Obviously, there's no way to appropriately social distance in a jury box. It simply can't be done within the structure that's there. So I know there have been discussions. Obviously, all the judges have different thoughts on this, but there have been discussions about how you deal with that in the courtroom. Do you clear the courtroom? Is the jury sitting, in a different location, not in the jury box, but still in the courtroom, to allow social distancing to occur? So those are the kinds of conversations that are happening. Same things going on with the district attorney's office and their grand jury. They meet in a small room. Obviously, that's not available. So when grand jury is allowed to meet again, what's that going to look like? They're going to have a much larger space as well. And some of the courts, like the criminal courts, we do essentially this really big jury call with hundreds of people, every quarter at the expo center. Not only can we not do that right now, that probably doesn't look feasible in the near future either. So what does orienting a criminal court jury for a quarter look like? The discussions have been, revolving on breaking that up into smaller portions, allowing in room size where you can have social distancing. We're just looking at lots of increased smaller events, replacing what had been, larger, more limited time events, lots more staggering just in general. But yeah, the jury trial itself is going to be a challenge. It's going to force us to certainly seat a courtroom radically different.
Thank you, Richard. And while you were speaking, I want to let everyone know we've got some very important people watching right now. And we had a circuit court judge weigh in and let us know addressing the deposition and subpoena question that at least for now, they are encouraging depositions by technology. And at least for now, I do not think you will find any of the circuit judges forcing an individual to attend an in-person deposition. So I think what I've seen in my own practice is that if all parties and all witnesses and everyone agree that they're willing to do in person, then you can do it in person and are certainly encouraged to social distance as best you can. But it sounds like the courts are not going to force anyone by subpoena or any other way to get together in the same room the way might have been done before the pandemic. We had one question just to clarify in terms of entering the courthouse. Is everyone who enters the city-county building being screened for temperature and symptoms, or is it only attorneys and litigants who enter through the main entrance?
I noticed that everybody.
I can attest that everybody that's coming through the doors have been screened.
Thank you, Karen.
Yeah, I think Karen was saying it's mandatory as a matter for General Sessions Court, but they are doing it. The public building authority for the building, for everyone coming in the main door, they are doing that.
Okay, thank you, Richard. Richard, when you were talking about jury trials, you mentioned in terms of once these orders eventually expire from the Supreme Court and other courts, we do have to talk about what things are going to look like moving forward, whether it be jury trials or the what we are sort of referring to as the new normal of what happens after this. And I know the KBA has talked about, we're putting together a CLE on how this is going to change the practice of law moving forward. And I'll open this to any of you. Do any of you see any of these changes being made on a permanent basis? Do you see once the Supreme Court finally says, hopefully sooner rather than later, that it's back up to the courts as to how they're going to operate completely? Do any of you, because there have been some good things that have come out of this, the addition of being able to conduct meetings like the one we're having right now through technology. Do any of you see any of the changes that have been put in place because of the emergency remaining after the emergency is over?
I think this is Mary Lindsey. I think as far as the cases that can be heard through the use of technology, I think that we'll continue to see that as an option. Now, there are certain cases that we're not going to use technology on, and those are like contested hearings, termination of parental rights, and transfer hearings. Those are going to require in-person hearings. But I think things that we can continue to do moving forward, I think that we'll see more use of that.
I concur. I think there'll be some permanent changes in General Sessions Court, because right now, because of the social distancing, we can't have folks behind the criminal court in the hallway, you know, working the deals out that they normally do. And we can't certainly have the civil attorneys coming and, you know, doing a call out for all their clients. There's no place for an attorney and 10 litigants to go to try to work deals out the day of court. So right now, all the lawyers, and I know it's more work for them, but they have to work their docket before they come here to see the judge. And that is a whole new operation, both on the crim and the civ side. But I do think that's going to maintain moving forward because it's so much more efficient for the docket itself to get all that done beforehand. So I think that's certainly going to be the case. And I also, you know, as we're moving forward, ever since March the 13th, the day that this first started, the 5 general sessions judges and the DA's office and the PD's office and Jonathan Cooper, who is kind of the lead attorney for the local defense bar, they have been in a weekly meeting every week. Sometimes those meetings last 2 hours, talking about how do we best serve our most fragile, most at-risk litigants. And, you know, those are the ones who are in jail for some reason. So there's been a collaborative process trying to figure out what's the best way to address all of these issues, both now, the last 8 weeks, before we got the reopening, if you will. And at this point now, moving forward, and then for permanent restructuring kind of how things are done in the future. And I agree with Mary, there are going to be some instances that will always rely on technology now, or at least prefer technology, because it's just easier for everybody if folks aren't having to be moved in certain cases. But that's not always the case. So, but I do think there are going to be changes that are permanent in nature, and that's one of them for the criminal defense bar and the civil bar to work their cases before they come to court.
Esther mentioned the weekly meetings of the justice system stakeholders. One thing that has come out of that impacts our process going forward is, I was looking last year, our jail count numbers were just over 1,500 people this week. Last year, it's just barely over 900 today. And that is a result of some of the action that the judges have taken to release inmates to the jail. The pretrial release program, which was already in its beginning stages, was ramped up on the quick. I don't see that going away anytime soon. That's been very successful. Those folks have done a great job just allowing this to actually occur and allowing us to have those numbers down and ensure. I mean, thankfully, we've been able to ensure that the jail numbers have stayed low enough, and we've been blessed as well, but we've not had any cases there, which is just a tremendous accomplishment of all the folks involved. And like Esther said too, the judges I talked to, you know, it's mixed on technology. When a screen is fuzzy, nobody's happy that day. But I think by and large, most of the judges have been impressed with what we've been able to accomplish under the restrictions. And when you consider things like what's the cost of transporting an inmate from Maloneyville Road to the City County Building, you know, it's a low-hanging hearing, a smaller procedure. You know, I think it's reasonable to say some of that may be staying around an audio-video situation in the long term.
All right. Anyone else?
I was just going to also offer a moment of praise to the city county IT folks because they too are on the public payroll, and I think it's just important to note they have worked literally around the clock to get us up and running on audiovisual matters as hard and fast as they can. It's been amazing to watch that IT department just work their hearts out.
They've certainly proven how essential they are, but I think we all knew that before there was a pandemic. We have a specific question about civil summons for sessions. When serving civil summons for sessions, should we pick any Monday going forward like we did pre-COVID, or is there a priority docketing or until the backlog is dealt with?
With civil sessions, I've posted the new closure dates, and I have also put a note in the memo stating we have some Thursday dates that are available. To contact the clerk's office for those dates, because we're having to work with the assembly room. There's some dates that we cannot be over there, so I've had to update those dates. But Monday, Tuesday, Wednesday, Thursday, we're having court. Some of the civil matters I'm trying to move to some Tuesdays until we hear from the Supreme Court as far as letting us have detainers. So Tuesdays are free as well to hear civil matters. But just call the clerk's office and we'll give you those Thursday dates for the attorneys to work with.
All right. We also have another question about deposition subpoenas. I'll read it over the air, and if our judge wants to weigh in, he or she can. It's since subpoenas for in-person depositions will not be allowed, will judges enforce subpoenas for video depositions? And if any questions, if any audience members have questions that we're unable to answer today, you can be sure to, or you can send those to me or directly at htipton@watsonroach.com or to Marcia M. Watson at knoxbar.org. And we will get questions to the appropriate people to answer them if those people aren't here, or if we don't have the time here today. And we had one more. They really want to know who's being screened and where. And I think I know the answer to this, Karen, but someone says, what about staff and judges who are not entering through the main door? Are they also all being screened?
We're not screening them.
Not screening staff and judges?
That's that everybody's coming through the main entrance is being screened. Other than that,
No, other than that, no.
All right, thank you. I was wondering, just we can go around the horn here and I can call on people and pick on you and pretend I'm a law school professor. Karen, what's one thing that you wish that attorneys or litigants in your court knew that you think they don't know?
contact their clients and get the cases worked out. We're having a lot of difficulty with the defense bar not contacting us about their cases, about moving their cases. So we're just kind of in limbo and just moving them, and hopefully they'll get online and look for their court date, but they're not contacting the clerk's office, trying to move their cases or trying to work out their cases with the DA's office. I mean, that can be going on at this time, but it's not happening.
All right, thank you, Karen. Randy, do you have anything that you wish that attorneys watching right now knew about the operation of the courts?
I guess the one thing I would say is be patient, because we're kind of doing this on the fly. Like today, we thought this is our plan, and if something comes up that we didn't think about, well, we're going to deal with it there and fix it. And so that's been the way it was on Monday. That's been the way it was today. I'm sure as we go forward and get into these big dockets of 400 cases, there'll be things that come up that we hadn't thought about, and we'll have to decide and work that out basically on the scene or later that day. So just be patient. We'll fix it, but it may take us, a few minutes or maybe even a day or two to fix it, but we'll get it taken care of.
Thank you. Mandy, you've pretty much escaped my notice this whole time.
Lucky me.
and class is almost over too. Is there anything that you wish that attorneys watching right now knew about the courts and about the plan?
No, I just echo what Karen was saying about, working out those cases, getting in contact with the DA's office, trying to get some of the stuff cleared off instead of us just resetting. Anything that could be resolved needs to be resolved. So that would be very helpful.
All right. We do have one more specific question. What about subpoenas to General Sessions Court for depositions in aid of discovery? Are those being enforced?
So most of our subpoenas, yeah, go ahead, Karen.
I'm sorry.
No, go ahead.
Go ahead. No, go ahead.
Some of our subpoenas, like we had a few on the docket today in regards to actions to recover with TVA Credit Union. So a lot of those people showed up for court today, which we don't do a lot of. Most of ours is going to be heard in front of our judges. I always joke about being Judge Judy Court, but so those people had shown up for court today. So the attorneys went out, spoke with them, and made the arrangements with what they were needing to do with the subpoenas that came through our court today.
All right, thank you. And Karen, did you have anything else to add to that?
No, sir.
All right. Mary, how about juvenile court? Is there something you wish that attorneys who might be watching right now knew about juvenile court that you think hasn't been communicated to them?
Well, I think actually I touched on a little bit earlier, but I just want to reiterate, if they know that they have cases coming up, if they would go ahead and get in contact with that court worker, that case manager here, and go ahead and let it be known of their preference on how they would like to proceed, and so that we can go ahead and get their case set up, and instead of waiting till, you know, the day before or the day of even. So, you know, we would like to go ahead and get as many cases, you know, ready to go as soon as possible.
All right. And Kelli, how about you with civil sessions? Is there anything you wish people watching knew about civil sessions?
Mainly just, you know, keeping an eye on the cap number that our judges have asked for, the 50 cases. I know sometimes it's hard to do that because they're pushing out the work that they've been holding on to for a little minute until they know that court's back in session. But that's the main thing, is just, you know, try to watch what you're sending to the clerk's office to be served. That's really the main thing.
All right.
Any questions, call us.
Esther, how about you?
Just as best I can for the attorneys to please work their cases ahead of time. And as Randy said, we appreciate everybody's patience. We are working in real time to solve any questions or problems that come up. But we're just grateful for such an incredibly supportive bar through this whole process.
Thank you. And Richard, any last remarks from you?
The only thing I would add is, you know, don't let the technology intimidate you. This is new for all of us, and we've all had plenty of stuff go wrong. Fortunately, more things have gone right. You know, but let us help you. I know in Fourth Circuit, Judge McMillan has been very good about working with lawyers to use Zoom, and his assistant, they're available for you. In the criminal court, we're using the Microsoft Teams platform. So, you know, reach out to us. You know, we've been working with attorneys the day before, doing dry runs, that kind of thing, so you don't, you know, feel like you're going to be foolish when you get into your first Teams chat. So let us help you make that a good experience. We want to do that. I'm richard.major@knoxcounty.org. Happy to help.
Thank you so much. Well, Karen, Randy, Mandy, Richard, Esther, Kelli, and Mary, and please relay to Charlie that we really appreciate your time today, and we are very thankful that you are working so hard to assist the citizens of Knox County and the attorneys who practice here. Like I said to our audience earlier, if you have any questions that were not addressed, or if you're watching this later, you can send any questions through me or through Marcia, and we'll make sure they get routed to the right people and try to get the information to you. knoxbar.org always has as up-to-date information as you'll find anywhere about court operations during the pandemic and a lot of other matters involving the COVID-19 pandemic. So I appreciate everyone for being here today. Thank you all for your time, and thanks to all of our audience for attending. And please be sure to check out the calendar of these webinars moving forward. We've got another one next week with Judge Reeves about the federal court operations, and I'm looking forward to that. So thank you all, and have a good day, and good luck, and stay healthy.
Thanks, sir.
Thank you. Thank you.